Good morning, everyone. Thank you very much for being here with us this morning, particularly on such short notice. But I feel it's very important that we have a briefing to explain and to, I guess, to highlight the events of earlier this morning in the past few minutes. Let me first start by introducing everyone that's here at the table with me. To my far left is Pat Costello, outside legal counsel for the city. Lewison, Costello, Condon, and Pfaff. The city solicitor, Phil Nasrallah, seated immediately to my left. To my right is Doug Lewison, also outside counsel to the city with the same law firm. Lewison, help me with that, Lewison, Costello, Condon, and Pfaff. Jay Condon, the city's CFO, not the Condon that's partners with Mr. Lewison and Costello, and Kate Federoff, assistant city solicitor. So basically, I'm surrounded by 4 lawyers and the CFO. Just a few moments ago, I signed 2 agreements that settle all outstanding litigation between Brockton Power and the City of Brockton. One is the actual settlement agreement, and the other is an agreement to sell effluent water, wastewater from the Brockton wastewater treatment plant. And those 2 agreements together settle what I believe in a very favorable basis for the City of Brockton, all of the outstanding litigation between Brockton Power and the City of Brockton. I am settling on behalf of the city, not for other individual named defendants, and we'll address that a little bit later. When we're done with the briefing here, we will make available copies of all the relevant documents we have to distribute, and Attorney Federoff will distribute those as soon as we're done. I'd like to give a little outline as to how we got to where we are today. I want to have an opportunity for each of the people seated up here to provide some explanation of their roles in the process. And then when I think we've covered it all, I'll absolutely entertain questions. But let me lay the groundwork first. I think it's very important for me to start off by explaining why I have settled the lawsuits. I think everyone knows that I became mayor 13 months ago, so this has been a 13-month process to get to where we are here this morning. During the campaign, when I was running for mayor, I think I explained my viewpoint, my position very clearly as regards to where I thought the city was in relation to this lawsuit and what I thought the proper action was to take. Despite that, when I became mayor 13 months ago, I did not make any immediate changes in terms of the city's position or the city's defense. We continued to aggressively defend all litigation between the city and the plaintiffs, Brockton Power, with the same attorneys in the same manner that we always had. No changes. And I instructed that defense to continue. We continued to fund it. And basically, my role in the first 6 months, I think, was primarily to do due diligence, to become knowledgeable in all the aspects of the different disputes between Brockton Power and the city, and to, ultimately at some point, make a decision as to what the best course was for the city to take. Probably the really important point for me was at the end of July, when the Supreme Judicial Court decisions on appeals came down. And despite how some may have interpreted it, it was clear through the advice I was given by my attorneys that on all the important points, once again, Brockton Power had prevailed. Most importantly, that the permitting process that led to Brockton Power being issued the permits to build the electric plant, that process was upheld by the court. And I think even in addition to that, we were now out of appeals. That was the final appeal, and Brockton Power prevailed on all but one point, and clearly it left us in a precarious position. So after spending some time with both the solicitor and his team and our outside attorneys, I instructed the attorneys to begin seeking a negotiated settlement. that would be in the best interests of the city. And I think all along I've been very public in terms of what I thought the components would be of a fair settlement, that it would have to involve the City of Brockton paying no money at all to Brockton Power, that it would have to include a negotiated pilot agreement, payment in lieu of taxes, that was fair and favorable to the city. We needed to negotiate that up front. I wouldn't make a deal without knowing what the revenue would be. And we also would need some sort of upfront cash payment because it's going to take about 2.5 to 3 years to build the plant. And I felt that the city should begin to receive some benefits even during the construction phase of the plant. So with those parameters, I did instruct our legal counsel to begin to seek a settlement. And essentially, all I did was instruct them to go try to get it. I told them what it had to look like if I was ever going to agree to it, and to bring something back to me when they got it. So I was not necessarily directly involved in negotiations. I was the person who did instruct the attorneys to seek the settlement. Probably the biggest factors as to why I instructed them to seek the settlement was looking at the ramifications of those Supreme Court decisions on top of the decision that had been rendered a year earlier in the civil rights lawsuit by Judge Sorokin. And I'll allow Attorneys Lewis and Costello to speak on that in more detail. But it was clear to me through the briefings with our attorneys that Sorokin's lengthy, detailed decision did not bode well for the city's chances if we continued to litigate the civil rights lawsuit. And that then compounded with the Supreme Court decisions that exhausted all of our appeals and came squarely down on the side of Brockton Power is what got me to the point where I decided it was time to see if we could get this thing settled. Around the same time in August, you may recall that I did reach out to the City Council and try to get them involved in the process. We requested, I requested with the Council that they convene a special meeting to be briefed by the city's attorneys. I felt that the developments were that significant and that I now had a good idea which direction we were going, that I wanted the Council to be fully briefed by our attorneys so that they would know exactly what I knew. Unfortunately, the Council did rebuff my efforts to do that. That meeting did not take place. However, I did send all of the recap of all of the litigation and the recap of the expenses, both current and projected, that I had planned to have the attorneys present directly to the Council. I did send all of that information to the councilors. So in August, they had basically the same summary of the status of all the litigation. They had the same accounting for the legal expenses that had been incurred. I think at that point about $1.2 million. Today, we're over $1.5 million of the taxpayers' money that has been spent to defend a lawsuit that my own attorneys tell me we have little or no chance of prevailing in. And I'll let the attorneys speak to that a little bit also. And it's clear that we're at the point where to do anything other than to try to settle this lawsuit would be irresponsible. It would place the city in great financial jeopardy. I think there was a very high likelihood that we would spend a couple $1 million more additional taxpayers' money on top of the $1.5 million that's already been spent to ultimately get to a conclusion where we would not prevail. We would potentially owe tens of millions of dollars in damages. The plant would still be cited, and the city would have no bargaining position whatsoever to drive a good deal with the developers of the plant. So coming to that conclusion, really I think I can probably summarize it as easily as saying, and let me make the point, the legal advice along these lines all through this process of the past 13 months has been unanimous. The city attorneys involved, our outside attorneys involved, they have all been unanimous that the city should settle. And at the end of the day, I think that if the city spends $1.5 million on legal advice, we ought to follow it. And if I were not to follow that very expensive legal advice, I would be negligent. I would be putting the city in an untenable position, potentially leading to financial receivership, bankruptcy. We would place the city's financial future at great risk, and would hurt all the residents of the city. So we get to the point where this fall, the attorneys are able to bring back a proposed agreement that meets all of the criteria that I laid out for them. And in November, mid-November, late November, somewhere in that neighborhood, mid to late November, they brought me the proposed settlement. I spent quite a bit of time reviewing it with our own attorneys. I think that Kate and Phil have spent more time with me than my family this past year. But after reviewing it, it did accomplish all the goals that I had. I do believe this is not just getting rid of a loss. This is a good settlement. We'll talk about the benefits. But over the next 20 years, this agreement will bring $82.85 million to the city of Brockton. And I think the time has come for us to stop spending millions of dollars and start collecting millions of dollars. So the attorneys brought me the settlement in late November. After reviewing it, I signed off on it. And at that point, the attorneys reached out to the legal counsel for the city council. Through this litigation, because the city council is a separate defendant in the suit, they also have their own attorney representing them in this matter. As a matter of fact, they're one of 8 total defendants in the suit who all have very high-priced lawyers who we're all paying for. And that's why the legal bills are so high. And not to criticize all the attorneys at the table here, but the fact of the matter is that the city council has its own attorneys representing them in this matter. So the outside city council, attorneys Costello and Lewison, did at that point communicate to the city council's attorney the terms of a proposed settlement, and actually then subsequently provided a copy of the actual proposed settlement. On or about the 1st of December, the city council had the proposed settlement in front of them, and they were being advised on that settlement by their attorneys. In fact, for the next 2.5 months, the city council took no action, although they met, I believe, on 5 separate occasions in executive session with their attorneys to discuss the proposed settlement, and failed to ever take any action. I believe that attorneys Costello and Lewison were invited to one of those meetings, attended one of those meetings, so that they could be available to answer the council's questions directly. To clear up one misconception, I was not invited to any of the meetings. I didn't participate in any of the meetings, and I have no idea what was said or not said in the room. All I know is that after 2.5 months and 5 meetings with attorneys, the city council was declining to take any action on the proposed settlement. And I think at that point, about 2 weeks ago, there was a communication from the city council's attorney to Brockton Power's attorney that not only were they rejecting the settlement, but they wanted to initiate the litigation. They were sending interrogatories that they wanted answered. That was very disappointing news to me. I think that for 2.5 months, I was very cognizant of and respectful of the city council having the opportunity to do their own due diligence, to have their own attorneys to consult with. And I really believed that the council would join me in settling the suits. And I was very surprised, and I was disappointed that that didn't happen. But that's the situation 2 weeks ago. So at that point, I did call the lawyers back in. I told them to reach out to Brockton Power and see if we could resurrect the settlement without the city council being a party to it. And that's what's occurred over the last couple of weeks. That's what culminates with these agreements that I have signed this morning. I'm going to have all of the attorneys, I think, give you a little perspective as to where we are, and then I will just outline quickly what are the benefits to this deal. Well, let me mention the financial benefits quickly, and then we'll get back to it. But then I want to give the attorneys a chance to speak. The agreement that we have calls for Brockton Power to make annual payments to the city, the total $4 million per year. It's a guaranteed $4 million per year to the city. $3.9 million in lieu of taxes, $100,000 for the sale of the sewer water that we currently pump into the brook every day. The value of that over 20 years is $80 million. $80 million to the city of Brockton. That's property tax relief, that's cops and firefighters and teachers that we would not be able to afford otherwise. It is critical to the city's financial future to have that revenue and to have it start coming in. In the meantime, we also negotiated community benefits, some immediate direct payments to the city that will come to the city the day the shovel breaks the ground. The day the shovel breaks the ground down on Oak Hill Way, there will be a payment in the total of $2.85 million to the city. And that payment I have designated to be distributed as follows. $1 million will be directed to the Brockton Public Schools. $1 million will be used for public safety, and the $850,000 will be used for city recreational purposes. And specifically, the $1 million to the schools, I will ask the school committee to consider spending that $1 million on technology for students, along with restoring middle school sports. Two major cuts in this past year's budget that I would like to see restored with that $1 million. Ultimately, that will be a decision that's made by the school committee, but that's my request. At this time, my intention for the $1 million for public safety is to purchase a new ladder truck for the Brockton Fire Department that's desperately needed. In the event we're able to make that purchase without the $1 million, in the meantime, you know, it'll still go to public safety. That $1 million will be directed to public safety. And the $850,000 for recreation here in the city will be used primarily to build an artificial turf soccer football field, something that I believe is a critical need here in the city, that I believe that this settlement gives us the opportunity to do something that we're just never going to have the money in the budget for, and will benefit a lot of the residents of the city. An artificial turf field that can be played on 24 hours a day, 7 days a week, I think will be a big benefit to the city, to those who use it, and to the city as a whole, to the quality of life here in the city. So at this point, I think I'd like to call on each of the attorneys to just give you a little overview of their role in this process and the advice that they have given me. And I guess I would start with attorneys Lewison and Costello, because they are the lead attorneys on the $68 million civil rights lawsuit with the city. So whichever one of you two gentlemen would like to make a comment?
Never give an open mic to a lawyer.
Yeah. That's why I tried to get all my stuff in now, because I know that,
You'll never hear it.
yeah, I won't get back on.
We were retained, our firm was retained to represent the city and all the other individually named entities and defendants were also represented, all paid for through the City of Brockton's revenues. We aggressively undertook the defense of the case, which is pending in the federal district court, and which has a large range of civil rights allegations against all of the individuals. Most importantly, and which was a very motivating factor, was that from the outset, we filed an omnibus and very extensive motion to dismiss the allegations. We confronted the allegations up front. And what is most important in the decision-making and forming our opinions going forward and giving the advice to the mayor about the course of this litigation was that the Judge Sorokin, in a very extensive, a 43-page decision, I believe, denied the motions to dismiss, and in fact said quite clearly, if these facts are proven before a jury, and this would have been presented to a jury in the federal court, if these facts as alleged in the complaint are proven, this does constitute civil rights violations. And what that left us and forced us to advise the mayor is to say, the exposure, the extent of the damages that are being sought by the plaintiffs, and as the court says, if proven before a jury, would have been millions and millions, close to $50 or $60 million in damages. To litigate that case would have cost additional millions. And then finally, it was quite clear, given the dual track of the litigation going on about the permitting and the appeals, culminating ultimately this summer with the SJC decision, it was clear that the plant was going to be built, that they were winning all of those permitting and legal battles. So the plant would come in. Very strong likelihood that if we went to a jury trial, the jury could find a conspiracy to violate civil rights to prevent the plant from being built. So you would have a triple whammy, if you will, to the city. The cost of defense would be extraordinary. If we lost before a jury, the damages would be astronomical and catastrophic, and the plant was coming in anyway. So that was an easy and appropriate decision. I believe our opinion or advice to the mayor was appropriate to say, negotiate the best deal and a favorable deal for the city of Brockton to get millions that would not otherwise come to the city, because when and if the plant was permitted by the state without an agreement, the plant would not be required to spend or pay to the city all of these community benefits and the pilot payments. So it was clear that this was the appropriate and necessary course, and ultimately, not at the end of a shotgun, but quite differently, was a negotiated arm's length deal that has brought a lot of benefits to the city.
Yep.
Yeah, I think if I may, one important factor was that we held in consideration was as they were approaching, Brockton Power was approaching and becoming closer and closer to obtaining all that they sought, it would have been clearly less viable to have any negotiation with them for community benefits, which the mayor was able to obtain. As they were going to cross the goal line, they would be less inclined to sit down and talk about mutual benefits for the city. So the fact that we were able to obtain this during that timing, I think, was a particular coup for the city.
Yeah. And I may just add briefly, in conjunction with what Doug and Phil had just said, when we were considering our posture in this case, there were three main parameters that we looked at. Number one was the litigative risk and the cost of continued litigation. As Doug and the mayor had just stated, the risks were substantial and the costs were substantial. Given the amount of money that had been spent to date, I would clearly suggest that that is the tip of the iceberg and what the city would have had to bear in legal costs had this matter proceeded through full trial. Number two, we always had in mind the likelihood of the success of the permitting process for the plant. As the mayor had noted, a threshold point in this whole situation was the SJC decision that was rendered in July. At that point in time, where the SJC, the ultimate arbiter of this dispute, upheld all salient points of the EFSB permit that Brockton Power had obtained, it appeared to us that the proponents of this project were very likely to obtain all necessary permits and approval that they would need to ultimately develop this plant. That was a key consideration. And third, as Phil just noted, we were always cognizant and cogent about what benefits could the city attain from the resolution of this case. The ultimate victory we could have obtained in this case, had this matter gone through full trial, would be the dismissal of the 1983 claims against all the defendants. Rest assured, that will be fully achieved through this settlement agreement. The settlement agreement will dismiss any and all claims against all city officers, agencies, boards, the city itself, and will result in releases issued by Brockton Power and the defendants mutually with respect to all claims. In other words, the case will be dismissed, the substantial claims that have been asserted will be dismissed, There is no admission whatsoever of any liability of or wrongdoing by the city or any of its officers in this matter, and we will ultimately walk away from this litigation without paying a penny in damages. That's a very key factor here. In addition, because of the timing of this settlement, we were able to negotiate a very substantial community benefits package and very favorable pilot agreement terms, as the mayor had outlined. So we deemed it appropriate at this point in time to take advantage of the opportunity that was presented to avoid the substantial litigative risks and costs and to cement and nail down a very solid and beneficial package for the city. In essence, that's why we're here today notifying the public of this settlement agreement.
And I think a couple of the other quick factors I'll mention, then I want to give Phil a chance to speak for a minute. But in terms of the timing, we're at a crossroads right now. There are no more appeals. There are no more stalls that will work. Our two options are to settle or go to trial. Those are the options. And the federal judge has made that very clear. And the discovery and deposition phase is ready to begin. It cannot be prolonged any further. And that phase alone will cost the city a couple $1 million. So we really were at a crossroads where the stalling tactics of the past, the appeals, those have all been exhausted, and it was time to make a decision, and that's the decision that I've made. And as the attorney said, it's actually a very easy decision. When it's mapped out to you clearly, it's an easy decision to make, that it does not make any sense for us to continue to throw good money after bad with an outcome that's not going to be in our favor and with the risks, financial risks to the city that are involved. I think the other piece is, going back to that Sorokin decision in 2013 that I spent a great deal of time being familiarized with during the first half of 2014. As Attorney Lewison said, the judge was pretty clear that, you know, if proven, the city's liable. I mean, that decision is full of smoke signals that we're in big trouble. And the reason we know we're in big trouble is because we know what it is they're going to discover and what they're going to find out in the deposition. It's not like we don't know what they're going to have when we get to trial. We do know. And we know we're going to lose. So to barrel into this and continue to spend these millions of dollars when we know what we know what the judge has said, it would have been totally irresponsible on my part to allow this to go any further. And I did not come to the decision lightly. When I say it was an easy decision, I mean that the choices were clear and there was never a second of hesitation from my part as to which was the right decision. I think I'd remind folks that, you know, we took 13 months to get here. So I think that we've been very cautious and thoughtful and deliberate through this process, but it brought us to the point where we're at the crossroads and a decision had to be made, and this decision is the right one. And I feel very good about what this does for the city. It creates jobs. It helps us to provide property tax relief to the taxpayers in the city. And I think it's really important for the city, too, just to be able to put this whole issue behind us. The divisiveness that it's caused in the city is not good for our image. It's not good for the people who live here. It's been long enough. It's time to settle it, put it behind us, and go forward and start reaping the benefits instead of paying the costs. So on that, Phil, I want to give you a chance as the city solicitor to chime in here.
Well, thank you. As this was materializing, the analysis of our litigation position, the law department also undertook to examine some collateral issues we thought would be very important and vital in making a determination as to how to conclude this matter, and that entailed the executive authority to resolve this case and to enter into any new contracts, as well as what the legislative roles would be. And just in giving a brief analysis and history of the whole process, back in 1999, there was a 30B process for the sale of the surplus property, being the effluent water, and what we were going to do with it and how we were going to sell that. In February of 2000, February 14th, in fact, the Brockton City Council had voted to approve an order allowing the sale of the effluent to the highest bidder. At that time, the highest bidder, in fact, the only bidder, was then Brockton Power, which had won the bid. In July of 2007, Brockton Power then appeared before the EFSB, filing plans for its future in this process. They appeared before the Environmental Siting Board, outlining what the project would be. Approximately a month and a half after they filed, the Brockton City Council then moved to create an amendment to their earlier order, calling to have a two-thirds vote for the sale of the effluent water. That two-thirds vote came under analysis by the law department as to whether or not that was viable and that would withstand scrutiny. We determined after analysis that the 2007 amendment was invalid and would not withstand attack. The basis for that was because, firstly, the amendment was clearly targeted for one particular company. In calling for a two-thirds vote by a city council on votes such as this was completely contradictory to state statute, parliamentary procedure, Robert's Rules of Order. And being primarily in contradiction to the state statute, it would fall and then revert back to the 2000 order, which in fact had granted this bid to Brockton Power. So we do not believe we wanted to open up any doors allowing further litigation on what we felt was an invalid, what we call in law, ultra vires order. And we made the determination that that 2007 amendment would not withstand, thereby validating what Brockton Power had obtained in 2000. We also determined that the authority to resolve the litigation was clearly an executive function within the mayoral provision and was specifically not a legislative function. Legislative authority does not share the same platform with executive functions, and in some instances vice versa. So it did not entail anything other than the mayor making the determination to execute the documents to resolve this litigation, as well as enter into new contracts with Brockton Power or any other collateral company that it saw fit. On that basis, we rendered the advice in a multi-page opinion to the mayor that he was in correct direction by taking the action he has explained this morning.
And if I can, anyone else want to jump in for a second? I think we did put together some exhibits, and I just want to take a minute to highlight them. I won't read them all to you. But I do want to address, I know that not everyone in the city is going to agree with this decision. I know that people who live near the Oak Hill Industrial Park have concerns, and I want folks to rest assured that I am completely satisfied that the construction of this plant poses no health risk to the people who live in the city, including the people who live nearby. If you look at the aerial photograph of where the plant will be sited, it's in the middle of the Oak Hill Way Industrial Park. As you see from looking down from above, it's a very suitable site. First of all the infrastructure you need for an electric generating plant is already there within the confines of the industrial park. So the electricity transmission lines, the gas transmission line, and the sewer treatment plant are all within the confines of the industrial park. So this requires no construction or infrastructure outside the boundaries of the industrial park. You can also see, despite what's been represented at times in the past, that it's not in the middle of a residential neighborhood. It is not on Main Street. In fact, it's about 1,200 feet to the closest house in one direction, and it's 1,500 feet and 1,700 feet in the other directions to the single closest residence. This is not in a residential neighborhood. It's in the middle of a heavy industrial use, commercial industrial park. The concerns, the most specific health concern that's been raised is around this particulate matter 2.5, PM 2.5 as everyone calls it. And I think that there's been a myth that somehow the air quality in this part of the city is different than the air quality in the rest of the city. Well, the science just doesn't prove it out. And 2 years ago, in 2013, the state installed a monitor, an air quality monitor, on the grounds of the Gilmore School to measure 2.5. We've been measuring this downtown on the roof of the post office downtown for over 10 years. But in 2013, a similar monitor was put in right near this proposed site. The data is readily available from the DEP, and it shows that the readings, the PM 2.5 readings at the Gilmore School have actually been slightly lower than the readings at the Commercial Street Post Office. So I think that dispels any notion that the air is any different or of any less quality in that part of the city. So I do believe the location is suitable. I do believe the technology is safe. Numerous state and federal agencies have to sign off on this type of plant being constructed, just like they do with the new plant that's being constructed in Salem. And then I think an important side note is that in this final negotiating stage in the last couple of weeks since the City Council chose not to accept the settlement, we did, Kate, I'll let you help with the language, but we were able to get additional safeguards built into the agreement that protect the residents of the city even further. The agreement now requires that all data, record keeping, all of this extensive data that the plant is required to report to DEP will also now be required to be reported directly to the city. So we're not relying on a third party to keep track of it. If there were ever any type of an issue with the emissions, and I firmly believe there never will be, but if there were, we would know about it immediately. We would be in a position to take action immediately to safeguard the residents. Another contention from folks that were concerned about this electric generating plant was there was an issue raised of using weather data, meteorological data from Logan Airport as opposed to Taunton. And the feeling of some was that the Taunton meteorological data should be the one that's used, being more representative of Brockton. And that's called for in this agreement. So it will be the Taunton meteorological data used for all of the metrics around measuring this plant. I guess, Kate, in terms of environmental, what else in terms of environmental?
That really sums it up. One of the major components of the air permit appeal was the fact that the data they were using was supposedly not properly representing the city. So they've properly located the site. That was a second contention, that the site was not actually situated where they claimed it would be. So that's been all adjusted in conformance with our request.
So this, I think this just built additional safeguards into the agreement that does protect the residents. And it's important to note that the plant has to meet some very strict federal and state guidelines around their emissions. In fact, guidelines that are stricter today than they were 8 years ago when the plant was originally proposed. So the bar has even been raised in terms of safety since the time this process began of the siting of the plant. And they will still have to perform for the DEP to obtain their air permit. And we're not doing anything to preempt that. We expect the DEP to very vigorously make sure that the plant complies with all regulation around its emissions. So I do believe it's a suitable site. I do believe that it will have no effect on air quality in the city. I do believe that we have put additional safeguards in to protect the residents. So it's not just about the money. I would not make the deal if I thought it posed a risk. It just doesn't. The science shows it just does not present any additional risk to the folks who live in the city. In terms of those air quality standards on PM 2.5 in the city right now, they're only about half of the allowable federal guidelines. And those guidelines are designed to protect the most vulnerable people who live in the community. Elderly, young children, people with asthma, breathing difficulties. Those guidelines are designed to protect the most vulnerable residents, and the readings are half of that. And that the reports show that this will have a de minimis effect. And I hate to use a legal Latin term, but that keeps coming up. One of the things I learned from the lawyers, which means negligible. It may tweak the needle slightly, but not enough to even be of any consequence. So I think that this is a good day for the city. I think it's time to put this behind us. I think we've struck a very favorable deal. $82.85 million to the city of Brockton over the next 20 years. And we've stopped the bleeding of millions of dollars of taxpayers' money being spent on outside attorneys trying to defend a case that they themselves tell me we are not going to win. And that's ultimately the decision that I made in seeking these settlements. And I think that these settlements achieve all of those. And I guess the last note before I take questions, I think it's important to note that all of these attorneys that are sitting here at the table representing the city were all here long before I was. This is the same legal team that's been litigating this case and these cases for years. I made no changes whatsoever in the legal team, either inside or outside, when I came to office. So these attorneys are the same attorneys that were advising the prior administration, and I thought it was important for the residents to know that no changes were made with the legal representation. And I actually hold all of these attorneys in the highest regard, and I think they've worked really hard on behalf of the residents of the city. So unless anyone else has anything, Jay, from a financial standpoint, would you like to make any type of comment?
Well, just a couple of things, Mayor. From the beginning, I've been around since the beginning on this. My view has been that if the plant were able to achieve the permits from the regulatory agencies in charge with environmental oversight, it was a good plant in terms of the economic benefit to the city. I believed that then, I still believe it, I just had no role in looking at the environmental process and the regulatory process. But I also thought the reason that we were losing case after case after case was that we were fighting against our own zoning ordinances. This is a specifically permitted use for that area in the city of Brockton. Nonetheless, that's the decision somebody else is making, not me. When the city was received its civil rights violation lawsuit and failed in its attempt to dismiss that lawsuit, I became concerned because the amount of money at issue there was well beyond the capacity of the city of Brockton to pay even in a fraction of what was being risked. So at that point, my internal advice has been, we've got to be very careful from here on in, because the phrase I've used has been, we're betting the ranch, and it's not our ranch to bet. And when that decision by Judge Sorokin came down, I had a meeting with the prior mayor, and I've also had meetings with Mayor Carpenter, and I think I've made a couple of public comments saying, we're in extreme jeopardy here, because my understanding was the case of the city in defending itself was rather weak. I don't want to say it was a loser, that's not my term, but I didn't think we had a good situation. So now I'm thinking we're in a much better situation than I would have anticipated some months ago. Not only are we walking away from a potential exposure that we can't afford, that we will likely to get hammered with, but we're getting money in that I wouldn't have thought was achievable, because I think the other side knew they had a pretty strong case. Yet there we have mitigation money coming our way, and we've got $4 million a year coming our way. Just to put that in perspective, every year the city of Brockton's tax levy recently has gone up by about $4 million. That's the potential levy. That's the 2.5% plus new growth. So what we've had available to us for additional revenue to spend, because the state isn't helping us out very much anymore, it's all on our backs. That's about $4 million a year. Here's another $4 million a year that'll be coming our way in just a few years. So I agree with the mayor. This is a good day for the city, and the ranch is safe. That's my final point.
Mr. Condon highlighted a very important issue that's been part and parcel of the analysis by the law department in part of the defense that we've been fighting against. This plant didn't pluck itself down in the middle of a commercial zone or randomly choose someplace in Brockton to the opposition of the people. They introduced themselves into an area specifically designed for that type of operation and business, in an industrial zone. And it would be permitted in that particular area. So in effect, we had been fighting against our own zoning ordinances, and that had been a major difficulty. How do you stop an industrial use from going into an industrial zone? And that that was a significant problem that we had to face, and I don't believe we would be able to overcome in the end.
So there were 8 permitting appeals, more if you count the cases that were consolidated. I was involved in, I was part of the team that defended those cases. And every stone was looked under, every avenue was thought about. It was an aggressive defense, and Phil's absolutely right. The major difficulty we faced was the primary issue in zoning is whether or not the use is allowed, and this was a specifically permitted use in that area. So on the permitting appeals, you were essentially arguing tangential issues, and it made it quite difficult, and as a result, we were unsuccessful in those appeals.
Which then gave credence to the support for the civil rights allegations, because it was hard or impossible to articulate the opposition to the lawful, appropriate citing of the plan, which was the basis for the plaintiffs to allege that there had to be something more to it, giving rise to the civil rights violations if, in fact, at every level, the state was allowing what the city level was denying.
And another component, which I think is important to raise, was this wasn't a settlement that was just presented to the city and we just simply accepted it. This was a hard-fought negotiation. At first, they were still seeking damages from the city, including attorney's fees, and that was a critical decision of the mayor to say, listen, with any damages, with any attorney's fees, any money coming out of the city's pockets, we're not going to settle. And that was a huge concession on the power plant's side. Furthermore, the benefits got richer as the mayor and the legal team negotiated with them over many, many months. So it wasn't just a settlement that was presented and we just signed off. We fought tooth and nail for every concession we were able to get and every benefit we were able to get.
Yeah, so I guess we'll go to questions here, but I think I just want to remind everyone that although it's clear that I have the legal authority to enter into these agreements and to settle this litigation, my first preference was to do it with the City Council. And that's why the settlement was sent to the City Council back around the 1st of December. That's why I patiently waited for 2.5 months without making any public comments so that the City Council, without any interference from me, would have the ability to really review the deal with their own attorney. And I had hoped to come to the same conclusion that I have, that it's the only reasonable, right course of action. But faced now with the situation where the council has chosen not to go that route, it's my duty, it's my obligation to make the best decision possible to benefit the residents of the city, and that's exactly what I've done. And it's time to get this settled, not time to go any further, and I think we got a very favorable deal. And I'm very appreciative of all the efforts that went into it, and I'm hoping that this will now allow us to put this all behind us and go forward. So I think unless anyone else has something they want to jump in with, I'll be happy to entertain questions.
Question.
Everyone up here is here to answer questions.
Sure. A question I want to ask is we know that this has been hot fought for nearly a decade, and that there was a small group of residents and an abutter who were fighting this particular cause. Is there a thought that they could end up going from one lawsuit to maybe another lawsuit from a particular abutter who has fought this tooth and nail?
I'll let the attorneys handle it. I'll just say that I'm very comfortable in my authority to execute these agreements. But I'll let the attorneys handle the legal questions.
I'll be happy to address the question. We obviously have no control over what private citizens or other private entities choose to do in terms of pursuing legal rights. What we can say unequivocally is that this particular lawsuit, which asserted 1983 claims against the city of Brockton, has been resolved and settled in its entirety. And as I noted earlier, the absolute best outcome we could have hoped for would be to have the charges dismissed against all city boards, officials, and the city itself. That has been achieved. Over that 10-year period, as Kate had noted, we have fought numerous battles on different substantive grounds, in conjunction with, at times, some of these interest groups, otherwise on our own. We have not prevailed in a single battle on the regulatory front. That, to me, is indicative as to the merit of the various defense positions that have been taken, or the various positions that can be taken to further challenge this case. And I think, as many speakers have noted here today, this resolution from the city's perspective is absolutely the best possible outcome we could hope for.
Just a follow-up question I would ask, and that is in regards to the settlement. A part of the monies aside from the water and tax payments, I know some of it, public safety, $1 million. There was $1 million that you have said, Mayor, is going to go to the school system, and the $850,000 going for the soccer field. Was the $1 million that was going to the schools in another body's hands? Was that in the city council's hands to do with it? But
yeah, so I think that this is, I'm going to let the attorneys
Okay.
give the correct legal answer,
Sure.
but it's essentially the same settlement that the council chose to take a pass on, but there were a few provisions of it that had to be renegotiated since the provision that we put in there, and one of those was the distribution of the $2.85 million, and I did change it a little bit. I feel that I'm directing this money towards some critical needs of the city that we don't have the money sitting around to pay for otherwise. We need a ladder truck for the fire department. We need to restore the cuts in technology in middle school sports in the schools. And we need to build a recreational facility here in the city. And this is going to accomplish all three of those goals using someone else's money. So that may have been tweaked, or that was tweaked since the version that went to the city council.
Mr. Mayor, isn't it true also that the willingness of the Brockton Power folks to provide $2.85 million initially was contingent upon having no continued opposition from the city council?
Right.
And when they wouldn't participate, the willingness to put $2.85 on the table wasn't there anymore?
Right, so I think the
correct.
attorney should cover that. So that 2.85 was lost when the council chose not to accept the settlement. So I think it took a lot of hard negotiating to get the full 2.85 back, because a portion of that clearly was to get the benefit of the council also accepting the settlement.
That's absolutely correct.
Yeah.
That's absolutely correct.
I guess one other follow-up, somebody else might have a question here. I think you had referenced something that had taken place in 2000 in regards to the sale of water, and then there was a change from how the vote was taken once there was somebody had won a bid, and that there was something that, was it all done around 2000 that all of these actions were taken? Was this a course of action that was taken later on after the bid was, some years later after the bid was won by Brockton Power?
So,
I think I'll let Phil
somewhat
have
later
that.
on, 2000 was the city council's vote to approve an order that would allow the sale of affluent water to the highest and best bidder. Then in 2007, shortly after Brockton Power filed applications with the state, the city council had amended their order, calling for a 2/3 vote to sanction any of those sales. And that 2/3 vote is invalid, in my
And
opinion.
this was after they were aware that Brockton Power was the.
A month and a
lead
half after.
And that made up part of the allegations in the civil rights claim to
Right,
say
you explained, correct.
that would be hard to articulate a valid basis for that.
And that leads to why the mayor's able to sign off on.
Yeah, so I mean, I'll give you the plain English version from all the lawyers. This sale of the sewer water to Brockton Power was authorized by the city council back in 2000. And essentially, it's been sitting here on the mayor's desk since 2000. The last two mayors have chosen not to sign it. I have decided to sign it. But it's legal, it's authorized, it's existing. The city council authorized it. And if someone wants to try to challenge my ability to do that, they can go right ahead. But I feel that we have a very strong opinion from the city solicitor. Phil actually gave me a legal opinion on this that goes several pages that we will make available along with the copies of both agreements. I'm going to make, and I don't have to, but I'm going to release it. I know I'm always accused of backroom deals and keeping secrets. I'm going to I'm going to actually authorize the release of that legal opinion that the city solicitor provided me, explaining the reasons why I have the authority to sign the agreement, and that's why I did sign it just a little while ago.
So there's no statute of limitation, there's no limitation?
No, there was no
timeframe?
there was no rescission, no revocation, there was no sunset clause on it,
Okay.
and there was nothing indicating that it expires after a certain amount of years.
Was that a separate project that was proposed at that time than the current project?
Yes.
In 2000, that
Yes.
was a different project?
Yes.
Same site,
That
same
would still be
site.
valid
Same.
even though it's a
It
separate
was-
project?
There was an assignment made by the prior company to the current company, so there was a full assignment of
For the
rights.
same purpose,
And
too.
just to clarify, the 2007 action was an
explain the
ordinance
same
and an amendment to an ordinance. That occurred in 2007, and just a
But the
technical-
agreement was for the same site, for the same purpose, and.
For the same use.
And the successor in interest is now, got all of the rights that flowed from that.
It was actually a
document.
smaller project back then, correct? Slightly
Yes.
smaller. Okay.
Yeah.
But yet, basically in the same.
Slightly
Yeah,
smaller.
yeah, slightly.
Yeah.
The 2007 ordinance, when that went into effect in the city, when the council voted it in, was that reviewed by the law department of the city at the time?
No.
They have legislative counsel.
So it
City
was reviewed by-
council has their own attorney.
So that ordinance was reviewed by their own attorney, but not by the city's attorney?
Well, I know it was not reviewed by the law department, the city's law department, my office. I don't know if they had it reviewed by their own legislative council. I can't speak to that.
Is that typical practice that the city's law department wouldn't review the city ordinances that are taking effect?
On this particular instance, we were not asked to review that particular ordinance.
Okay.
Mark?
What type of action do you anticipate from the council?
Well, I guess they'll probably be as disappointed in me as I was in them. So I'm hopeful that the vast majority of the councilors realize that I'm acting simply in the best interest of the city. There's no other motivation here. You know, I've got to believe that the councilors know what I know. They met with their attorney 5 times. So I've got to believe that they know what I know, and in their heart of hearts, they know I'm doing the right thing.
This might be for Attorney Costello. You mentioned a couple times that all the defendants would be released
Yes.
from the lawsuit. That includes former city officials as well as current city council, planning board, city itself, everybody.
Yes, the claims asserted in the complaint will be dismissed as against each defendant, and they will be released from any liability based on any prior actions they made.
And this agreement does not call for an admission of liability
Correct.
by anyone. It is full release, and it is a full dismissal of the case so that it cannot be brought back against them. So not a single defendant is left hanging out there, which the mayor technically could have said, I'm settling on behalf of the city, you guys are on your own. He closed, by executing this agreement, it ends the litigation for everyone. So a party who was named, who technically doesn't want to see the case settled, would be in the very odd situation of trying to demand to go forward to win a case at trial, which is exactly what we've already won for them. The best case going to trial would be for a jury to say, dismissed in your favor. This document already provides that to them.
Can you walk us through the process quickly about how that works? When will the defendants see their releases? Does it have to go through the judge and then to the defendants?
There's a bit of a litigation process going forward, where the parties have now essentially signed an agreement between the plaintiffs and the defendant city through the mayor. We anticipate now going to the federal judge and saying, Judge, we are reaching an agreement, a settlement agreement that is contingent upon certain subsequent actions to take place. So we're asking you to stay the litigation until those subcomponents, as envisioned within the agreement, take place, and then when they take place, we will file that ultimate stipulation of dismissal, which is the legal document that would then dismiss it all. But during that pendency, during the shovels, during the Brockton Power seeking the final permits, and before and until the shovels hit the ground, we're just going to stay the litigation with the court's approval to stay it.
So it essentially would be in limbo until
Yeah.
the shovels. actually.
That's a legal term. Yeah. No. The yes. It's yes. We're gonna a court-approved limbo, so that it's just going to stop. There's not going to be any pressure to litigate, to do discovery, or to spend money defending the case.
And where do the legal costs stand? Is it that the plaintiff and the defendants will, whatever costs they've incurred so far, are their own costs?
We're standing down,
The
and
city is
yeah,
paying.
in the
No retroactive.
in the normal course of things, when the defendants settle a case, 9 out of 10 times the defendants are paying money to the plaintiffs. The plaintiffs in this case have alleged millions of dollars of lost opportunity to run the plan, and they have expended millions of dollars in litigating all of those state proceedings and statutory proceedings which they won. At the outset of the case, they wanted all of that to be paid to them, and at the outset of the negotiations, they were looking for some money to be paid. The mayor said, the only way this case is going to settle is we're not paying you anything. In fact, you're going to pay us money, and that's the ultimate magic of this, is that we were accused, we collectively accused of a lot of things that cost a lot of money, and yet we're going to get paid, the city that is going to get paid through the mayor's negotiations.
Just a quick question, do any of the defendants have to sign off on anything, or is that not necessary in order to close this out?
The mayor has settled the case on behalf of the city, which is a defendant, and in this document it's referred to as the settling party is the city of Brockton. Derivative of that, once all these different elements of the agreement are met, then the plaintiff, the other signatory to the agreement, says, my side of the deal is I will dismiss all of those defendants. So we bargain the benefit for them, which is the ultimate dismissal.
And as noted previously, we have attained the absolute best outcome for each one of these defendants that is possible. They will be dismissed and released from all liability. We're going to file a motion with the court seeking to approve the settlement upon the terms we've negotiated. If any one of those parties wishes to go forward and tell Judge Sorokin he or she does not want to be dismissed and wants to remain in the case, that's up to them to do. But as of right now, we have achieved, by the mayor's direction, full dismissal of all claims against all city officers, agencies, and boards.
Current and past.
Current and past.
This might be for the mayor. If all goes as planned, and the final air permitting is done, nobody sues independently and tries to stop it, everything goes as planned, is there a timeline for breaking ground?
Well, I think that's really going to be determined by the developers and how long this all takes. But I mean, I'm guessing, that could still be a year away. Because as you said, they've still got to get the air permit. They've got a couple other things they've got to do. They have to close on their financing and things like that. But I mean, that's all on their side. I think the most important thing, as Attorney Lewison indicated, is it's a stand down. It's a stay right now. All the litigation stops. We've stopped it. And now it will be finally dismissed after we do the things we say we'll do in the agreement.
There's no one here from the developer or Jay Cashman or the attorneys?
They weren't involved in the decision.
Okay. It's an agreement with them, right? They have to sign the agreement as well?
They signed it before I did, I believe, right, Kate?
Yes.
Yeah, they signed first, then I signed it a few minutes before you walked in the room.
Did they say why they didn't want to come today to do
I didn't invite them.
You didn't invite them?
No, they're not involved. You're free to go interview them.
Yeah.
I don't represent them. I don't have any relationship with them. They were the other side of the lawsuit.
Right.
So, that's the other team. So, if they decide they would like to explain their position to you, they can. Not for me to speak for them. I thought today was important that we have this briefing because I think it's just very important that, who I care about being informed today are the residents and the taxpayers of the city. Those are the folks that I want to make sure are fully informed and have all of the information and have all their questions answered. And that's what we're doing. And as I said, as soon as we wrap up here, we've got copies of all the documents that I'm going to turn over to you immediately. I think actually, once we get the documents out to Phil is in the process, I think, of sending copies of everything out to the councilors. But once the councilors have received their copies, it's my intention to put them up on the website. And any resident that wants to have an opportunity to review them, it's all right there. it's a good deal for the city, and it's long overdue.
Any worries? I mean, the past year of your term, it's been difficult working with the city council, and it seems as though things were kind of smoothing out a bit. Do you, any worries or concerns? And moving forward, I mean, you got a budget that you gotta work on shortly and work with them.
Well,
Any concerns that this could harm any goodwill that you've made with the?
I'm doing the best I possibly can to work cooperatively with the council on every single matter that comes up. And, you know, I think from my standpoint, I'm working very hard to build a solid working relationship with them. And even if some councilors disagree with this specific decision, it should not interfere with our ability to govern, our ability to work together to do the best we can for the residents of the city.